Yes, Your Honor. The people call Officer Jacob Lieb.
Okay. All right, officer, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, you may proceed. Is L-E-I-B?
L-I-E-B.
L-I-E-B. My apologies.
Tonight's case opens inside Brownstown Township. A late-night domestic complaint lands in the station lobby. An officer with body cam rolling, two spouses with clashing stories, and a judge already policing the line between facts and hearsay. Watch the pressure points. Was a gun ever pointed? Did anyone have consent to access a phone? What got recorded, what got written, and what got left out? Pay attention to demeanor, the report, and the moments counsel tries to lock the officer into specifics, because the credibility battle starts now.
Good afternoon. Could you please state your name for the record?
Officer Jacob Lieb.
Mr. Lieb, where do you work?
I work in Brownstown Township as a police officer on patrol.
Okay. How long have you been employed there?
I've been employed at Brownstown for just under 2 years. I've been a police officer for 9 years.
What are your roles and responsibilities in this capacity?
As of right now, I'm a patrol officer on night shift in the Brownstown Township.
Were you working in this capacity on April 10th, 2024?
I was, yes.
And what were you doing that day?
Everything that would entail a normal night shift on patrol, answering calls for service, more specifically.
Could you just move up closer to that microphone and keep your voice up a little bit, please? Thanks.
Yeah, absolutely.
Could you repeat the answer just because it was a little low?
I was answering calls for service most of the night, including the call that we received.
Okay, and you indicated a call was received. Do you recall who that call was received from?
From our dispatch, dispatched me to the Brownstown Police Department station's lobby.
Were you in the lobby at that time?
I was not. I responded there.
And when you responded, did you make contact with anybody?
I did. I made contact with our victim in this case, Chantel Sadarsky, if I'm pronouncing that correctly.
And what happened when she was there?
So we were dispatched there in regards to a domestic violence complaint. I made contact with Chantel. She informed me that she had gotten into an altercation with her husband.
Objecting to hearsay.
Any response?
I can withdraw the question. We can
I'll
strike what
sustain,
you said
you can
about.
rephrase. How's
Yes.
that?
Well, I had asked what happened when she was there.
And he started to say what she told him.
Yeah, so we
So-
can, what he said before that should be,
Well, that will remain on the record, but anything, he didn't really answer it. He just started and she said, and then he objected and I said, I'll sustain it. So you can rephrase your question if you'd like.
You just saw the judge step in when the officer started to relay what Chantel told him. That's the hearsay boundary in action. Testimony must stick to admissible facts unless an exception applies. Notice how the prosecutor immediately reframes to demeanor instead of statements. Demeanor can matter. Appeared upset is observable. Repeating out-of-court accusations is not. This is a classic early hearing adjustment. Tighten the question, keep the record clean, and move forward without poisoning the well.
okay, I can rephrase the question, if that's okay. When she arrived, what was her demeanor like?
She appeared upset.
Okay. And did you make a report based off of, or did you make a report that night?
I did, yes.
And was your body cam on and functioning that night?
It was.
Key trio. 1. She appeared upset. That's limited but useful context. 2. The officer confirms he generated a report that night. Written reports become impeachment targets later. Every word and omission matters. Thy body cam was on and functioning. That's your objective anchor. Jurors and judges love video because it narrows disputes about who said what. File this away. Report plus body cam, the backbone of the state's narrative.
Did anything else happen that night?
I interviewed the female, Chantel. I also interviewed the other party involved, Andrew. They both completed witness statements, and I typed a report based off both of their stories.
I don't mean to interject, but one ththing I want to say, Mr. Rockine, you brought the thumb drive with you.
I had it, yes, Your Honor.
So you're just going to retain that. We're just going to know that that's the thumb drive. The exhibits go back to you, but
Yes, sir.
I remembered I told you to bring it today, and
Yes, and I have it.
okay. So that's the way we'll play that. I'm sorry. Go ahead.
The officer interviewed both parties and collected written statements, then kicked the file to the Detective Bureau. Standard workflow. The judge's quick note about the thumb drive exhibits is small but important. It's chain of custody housekeeping. If video comes in later, everyone needs clarity on what was provided and who holds it. Organization today prevents authenticity fights tomorrow.
I'm just trying to recall. Okay. And did anything else happen after those interviews?
No, I typed my report and submitted it to the Detective Bureau for further investigation.
Okay. Just one moment. Nothing further, Your Honor.
Cross.
Thank you. First of all, thank you for opening the door for me as I walked into the courthouse. I appreciate that. I appreciated that courtesy.
You're welcome.
Officer Lieb, let me, it's pronounced Lieb, correct?
Correct.
And you're in plain clothes, but you have a badge on. So are you a detective now, or?
Nope, this is my uniform for court today.
Yes, sir. I'm going to touch on a few different areas and try to get through them as quickly as I can. If I ask a question that's confusing, you just tell me. All right?
Okay.
Now, your answers, have to be verbal. So they have to be out loud as opposed to a nod or a shake of the head. You understand that?
Yes.
Defense opens friendly. Thanks for the door, confirms uniform, then sets ground rules. That's deliberate. Build rapport, appear reasonable, and then tunnel into report discipline. Notice counsel's rhythm. Did you write it? Review it? Train to include what's relevant? Satisfied it's complete? Each yes tightens the defense's future argument. If something isn't in that report, it's either not real, not remembered, or not reliable. This is the setup for later impeachment by omission.
You wrote a report in this case, yes?
Yes.
I presume at some point you've looked at it before you actually submitted it, yes? And I presume at some point you looked at it before testifying today.
Yes.
You reviewed it today in the prosecutor's conference room?
I did, yes.
Now, there are certain things about report writing I just want to kind of go through those relatively quickly. There's a purpose in preparing reports, yes?
Yes.
The purpose is to memorialize things that occurred.
Yes.
You try to write it as when things are still fresh in your mind.
Yes.
You try to document things that are relevant and important. Yes. And you're trained when you write a report to include the relevant and important facts.
Yes.
And you're trained to write an accurate and complete report. Is that true?
Yes.
And when you're satisfied, and when I started, officers actually wrote reports, but now you guys type them out. Yes?
Yes.
And so when you start typing your report and you finish typing it, you're able to review it. And when you're satisfied that you've discharged your duty to prepare an accurate, complete, and reliable report, you then print it and submit it as your official report in the case. Am I correct?
By confirming he's trained to document relevant and important facts and to submit an accurate, complete, reliable report, the officer raises the bar on himself. That's normal, but it arms the cross-examiner. If a dramatic detail appears later from another witness, or on social media, but isn't in the contemporaneous report, expect the defense to argue it's an embellishment. The theme: if it mattered, it would be in your report, right, officer?
Yes.
And you did that in this case?
I did, yes.
You also submitted body camera in this case. Am I correct?
Yes.
Now, you had body camera for when Ms. Scardarossi was your original encounter with her in the lobby of the police station.
That's correct, yes.
You have a subsequent body camera with her when you exit to hand her a blank written statement or a statement to fill out?
I would imagine this, is that on the same body camera?
Well, do you recall if it's the same body camera or not?
If you said subsequent, so I just wanted to clarify. It should be my same body camera, yes.
Yeah, but is it a different actual recording? Or don't you know?
I don't recall.
You actually then made a third recording where you recorded a telephone interaction with Ms. Scadarrasi, yes?
Yes.
Objection. He was testifying.
He's asking a question. He's asking a question, leading question. It's okay. It's cross overruled.
Yes?
Yes.
And then you were wearing body camera when you actually went out and spoke with Mr. Scadarrasi.
Yes, that's correct.
You reviewed your body camera before testifying today?
I did, yes.
How many different body camera did you review before testifying today?
Just myself.
Just your own?
My own.
Listen to how defense needles the sequence of recordings: lobby interaction, handing over a statement, the speaker phone call, the later contact with Andrew. The officer can't pin down whether certain handoffs appear on video and says, "I don't recall," multiple times. Important distinction. "I don't recall" isn't the same as "it didn't happen." But in a credibility contest, repeated memory gaps on simple logistics can soften a witness. Defense is building a contrast between the certainty of paperwork and the fuzziness of memory.
The ones that I just referred to?
Yes.
Lobby interaction with Ms. Scadarrasi? Yes?
Yes.
Body camera, where you handed her a witness statement to fill out?
If that was included in my body camera, I watched my body camera from the entirety of the interview in the lobby with Ms. Chantel Suttergoski.
I'm just trying to...
In other words, what you're telling us, you didn't see on that body cam, you handing her a statement to fill out?
That's what I'm asking you. I know my next question, Judge.
Is that what you're telling us?
I believe... can you rephrase the question? I'm trying to clarify. I watched my body camera in its entirety from my interaction with Chantel.
I understand. The end of your body camera, what was the last thing that you observed on your body camera with Ms. Scadarrasi?
I don't recall.
You just watched it.
I didn't just watch it. I watched it when I was preparing for this case. It was not just a second ago. I don't recall what my last interaction was.
How long ago did you prepare for testifying today by watching your body camera?
I reviewed my body camera footage on Sunday night while I was working.
All right. So I'm going to ask the same question the judge asked. When you reviewed your body camera, did you see you handing Ms. Scadarrasi a witness statement to fill out?
I do not recall. I did have her fill one out.
Did you see on your body camera you handing Ms. Scadarrasi a victim notification card?
Objection, Your Honor. Asked and answered.
Yeah, I think it is.
It's a different question.
Wow.
There's a purpose to this last question, if you let me ask it. And saying goodbye to her, like watching her leave the station.
If that was the last interaction, I don't recall if she was walking away or what my last interaction was. I would have handed her a victim rights card with the report number.
I'm just asking if you saw that on your video.
I don't recall.
Preparing. And how about, did you see when you were watching your videos in preparation for testifying today, your interview or your phone call with Ms. Scadarrasi that was on speakerphone?
I did see that, yes.
And you saw that in preparation for today?
Yes.
In your police report, you never wrote that Ms. Scadarrasi pointed, or that Mr. Scadarrasi pointed the barrel of the gun at Mrs. Scadarrasi's neck. Am I correct?
That's correct. I did not write that.
You never wrote that Mrs. Scardarossi demonstrated with her finger to her neck the barrel of the gun pointed at her. Am I correct?
Can you rephrase the question?
Yes, you never wrote in your report that Mrs. Scardarossi demonstrated the barrel of the gun pointed at her neck. Am I correct?
That's correct.
In fact, Mrs. Scardarossi told you that the gun was never pointed at her. Am I correct?
You are correct.
And in your report, you wrote, Chantel noted that Andrew kept the handgun in the holster during this incident and never pointed the firearm directly at her. Isn't that what you wrote in your report?
That is correct.
Here's a major moment. The officer did not write that a gun was pointed at Chantel's neck, and his report says she stated the handgun stayed holstered and was never pointed directly at her. That's significant. In domestic cases involving firearms, pointing versus not pointing can be the difference between charges and enhancements. If anyone later claims barrel to the neck, Cross will hammer this. Show me where the officer documented that. Oh, right, he didn't because she said the opposite.
One of the things that you do as a police officer is, of course, when you interview witnesses, you're trying to get information, right?
Correct.
And you're also trying to assess credibility, right?
Correct.
And you pay attention to whether a witness's story changes. Am I correct?
Correct.
And where the witness changes stories or changes the narrative, that could be evidence that the witness is not being truthful.
It could be, correct.
You weren't told, as your report reflects and as you testified a moment ago, that Mr. Scardarossi ever had the barrel of the gun pointed to Mrs. Scardarossi's neck. Am I correct?
You are correct.
You would agree that the neck and the head are two different parts of the body.
That's correct.
Pointed to the neck is different than next to the head, correct?
Correct.
Had the gun been pointed, or had Mrs. Scardarossi at any point said the gun was in any way pointed at her, head, neck, chest, anywhere, you would have noted that in your report. Am I right?
That's correct.
That's an important detail.
That is. Yes.
Defense forces a clean linguistic lane. Neck and head aren't interchangeable, and pointed at is different from near. Why it matters: precise body targeting can elevate threat perception. The officer confirms he would have documented any claim that the gun was pointed at any body part. He says she never told him that. That tightens the record around the original account. Holstered, not pointed.
And she never told you that?
She did not, no.
Now, Mrs. Scardarossi, well, strike that. You're aware that Mr. Scardarossi owns a company. Are you aware of that?
They may have mentioned it on scene. I don't know what the company would be, the name of the company or any of their roles in the company.
Well, one way to assess a witness's credibility, particularly in a case like this, is to attempt to corroborate what a witness tells you, right?
Correct.
So in the interview, Mrs. Scardarossi says that she owns a company. Correct?
I don't recall if she says she owns it or she works there or they own it together. I don't recall. Did
you do any research to attempt to evaluate that?
No.
Did you do any checks on Lara or on a state corporate website to see if that's true?
I did not know.
So you don't know if she was lying to you or misrepresenting who owned the company when she interviewed you?
Objection, Your Honor. All of this is irrelevant at this point, whether he did the Lara search and whether or not she had spoken about the business.
That he doesn't remember whether she said she owned it, he owned it, or they both owned it.
And I'm asking whether he did anything to determine whether or not she misrepresented that.
But then you said something about lying. Repeat your last question.
Certainly. You said, you didn't do anything to determine whether Mrs. Scardarossi was lying or misrepresenting her role in that company, did you? That's my question.
Okay, but he doesn't remember what she said. So I'm going to ask you to move on.
Okay.
That's not a proper question.
Okay, Ron. Now, in your report, you repeatedly referred to Mr. Scardarossi's phone as his phone. Yes?
I believe so, yes.
Okay. And Mrs. Scadarrasi referred to, when she interviewed with you or when you spoke with her, referred to Mr. Scadarrasi's phone as his phone, H-I-S, his phone, correct?
Correct.
She never said that his phone was, quote, marital property, did she?
No,
She never referred to it as marital property, did she?
no,
She never indicated to you that, well, it's ours, so I have I can look at it because it's part of the marriage.
Objection, Your Honor. Asked and answered.
We pivot to the phone. Everyone, including Chantel, keeps calling it his phone. Not marital property. Defense is setting the chessboard for a consent analysis. If it's acknowledged as his, accessing it at 1-something in the morning while he's asleep looks unauthorized. The judge trims a few argumentative edges, but the takeaway is clear. Language choices at the scene, his phone, become ammunition later when arguing consent, or the lack of it.
I think I've made the point. She referred, yes, Your Honor, multiple times. Now, it's important when you're interviewing a witness to actually to be actively listening. Yes?
that's correct.
So when the witness says something, to actually like pause and think, why did the witness use that word, or why did they say that? Yes?
It would be helpful.
Helpful.
Yes.
Mrs. Scadarrasi had characterized her conduct to you as vindictive. She used that word vindictive. Do you recall that?
I do not recall that.
Did you inquire for, let me ask you a question. There was a discussion about her sneaking into the home. You were interviewing her and she said she had snuck into the home at night, 1-something in the morning. You remember that?
I recall that conversation, yes.
Does it help refresh your memory about her referring to her behavior as vindictive?
I don't recall using that terminology.
Not you,
Hearing
her.
that terminology. I don't recall.
Okay. Let's talk about what consent means. You're familiar with the word consent or permission, yes?
Yes.
As a police officer, you know consent means that someone is giving you permission, or that another person has the ability or has said it's okay to do something, yes?
Yes.
Okay. In regards to the phone, I mean, there's obviously a couple of different ways as a police officer to establish consent. I'm going to go through those with you, okay? One is if a person says, yeah, I had consent, like they actually gave me written consent, for example. Yes?
Yes.
Another is if there's actually circumstances that show that the person did or did not have consent, right?
Yes.
Mrs. Scadarrasi told you that she did not have consent to access Mr. Scadarrasi's phone, correct?
I don't know if she used the word consent, but
Finish your thought.
she told me that she went over there and retrieved his cell phone.
Objection, hearsay,
All right.
Your Honor.
This is actually a prior inconsistent statement because I asked Mrs. Scadarrasi these questions, and
So you're just saying you're going to use it for impeachment?
correct, Your Honor. Yes.
Overruled. You already asked a lot of hearsay questions.
So these are all,
They're not all inconsistent statements, so I'll.
well, the record will bear that out, but I'll make my argument to the court at the appropriate time. She specifically said on the issue of consent, there's no way he'd ever give me any kind of code while he is awake. Remember her saying that?
I believe so, yes.
That's evidence of a lack of consent.
Watch this careful threading. Defense elicits that Chantel said there's no way he'd ever give me any kind of code while he is awake. That sounds like no consent. When counsel nudges the officer to label it legally, the judge sustains properly. Officers give facts. Courts decide law. For viewers, facts suggesting absence of permission, sneaking, no code, sleeping, are powerful, but they don't equal a legal conclusion by themselves. The judge is keeping roles clean while the defense plants the seeds.
Objection, that calls for a legal conclusion.
Any response to that?
What's that?
She said that calls for a legal conclusion.
I don't know that it does, but I'm asking for the officer's assessment. So,
He's not a lawyer. I'm going to ask you to move on.
Okay.
Stay in the objection. If you answered that, I'm striking it.
she never said to you, I had permission or I had consent to access his phone at while he was sleeping at 1 something in the morning, did she?
No, she did not.
And she indicated to you that they were separated, with marital separation.
No.
Okay. Tell me about his computer. What did she say about his laptop?
Your
I don't recall.
objection, irrelevant.
Well, it goes to it's impeachment again. Goes to prior inconsistent statement.
Well, you've got to be more specific.
I'll be more specific. She never even mentioned.
Well, I'm asking you to be more specific with what statement that's.
Oh, sure. Sure.
Well, she never denied that she.
You know what? I'll withdraw and I'll rephrase it to make it easier. In your interview with you, Mrs. Scardarossi never said to you, so by omission, she omitted sharing with you that she'd attempted to access Mr. Scardarossi's laptop in his home that night. Am I correct?
I don't recall. She attempted to retrieve a passcode from his cell phone.
On his cell phone?
Yes.
She never told you. You have no recollection of her telling you that she attempted to access his laptop. Am I correct?
I don't recall that.
Would you agree that if she had indicated that you made reference to the phone in your report, correct? Yes. There's no reference to the laptop in your report. Isn't that true?
That's true.
And had she told you that she tried to access his laptop, that would be something that you would have put in your report?
Depending on if it was if she removed it from the home or if it had anything to do with these allegations, it would have been noted.
Okay. All right, I want to focus for a second on one more issue with Mrs. Scardarossi, if I could. So, between 1:40 and about 1:50 was your first conversation with Ms. Scardarossi in the lobby of the police department. Giving you a time frame, about 10 minutes. Yes?
Is that a question?
Yes.
Yes, it sounds pretty accurate.
During that interaction with Mrs. Scardarossi, she never said to you that she disabled any of the security cameras in the home. Am I correct?
You are correct. She did not tell me that.
Your second conversation with Ms. Scardarossi was between 2 o'clock and 5 seconds or so and 2:09, somewhere in that range, about 9 minutes.
That sounds accurate.
She didn't mention it the second time either, did she?
I don't believe so, no.
We asked her to write out a written statement, yes? Or if she was willing to write one out?
She was willing and she did, yes.
Now you don't tell people what to write in their written statement, correct?
Correct.
You don't tell them to conceal or omit facts, do you?
I do not.
You don't say, look, just put part of this in there, but anything that may look bad for you, feel free to leave out. You would never do that.
No.
And if I were to say to you that there's a claim that you told Mrs. Scardarossi not to include any reference to the cameras being disabled, you would say that's false.
I would say that's false. Correct.
And if I were to say to you that Mrs. Scardarossi or someone, there's a claim that you told her to just exclude certain information from her written statement, you would also say that's false.
Correct.
As Mrs. Scardarossi was leaving at about 2:37 in the morning, so we're now about an hour or so into your interaction with her, she's still at the police station. And as she's about leaving, there is a discussion about the interior kitchen camera, correct?
I don't recall.
Okay. At that point, prior to her leaving the police station, she never mentioned to you that she had disabled the front door ring camera, correct?
That's correct.
At 3:41, now at 3:41 in the morning, you call Mrs. Scardarossi on the phone, yes?
Mr. Scardarossi?
Mrs. Scardarossi,
Mrs. Skardarowski, I did contact her.
Now, this is 2 hours after your first interaction with her.
Yes,
After multiple interactions with her in the lobby of the police department, yes?
yes,
And after having gone out to the scene and speaking with Mr. Skardarowski, am I correct?
correct.
And you return, and Mr. Skardarowski had shared some information with you. He had shared some Ring camera videos with you.
Correct.
You got information from him about the Ring camera videos that Mr. Skardarowski didn't tell you about.
That's correct.
Final beats today. Defense highlights omissions. No laptop access noted, no mention of disabled cameras during the multiple lobby interactions, and no reference to a front door Ring camera being turned off. Hours later, the officer calls back at 3:41 a.m. after speaking with Andrew and learning about Ring videos Chantel didn't mention. That tees up the core disputes. 1. Credibility of initial statements versus later claims. 2. Consent to access the phone. And 3. Whether the firearm was ever pointed. We don't see a ruling yet in this excerpt. But if the judge weighs probable cause or credibility later, these exact omissions and report lines will drive it.